Let's bring in our guest to discuss this. National Trial Attorney Michael Jaafar is with us. And Michael, we just heard the second witness for the defense. This is an auto forensic engineer. How do you think he did? And has he put the defense in a position where Bud Ackerman shouldn't have to take the stand to tell his side?
Well, you you ended that question with a second very important question. Let me answer the first one because it's a little bit easier, but I'm glad that you asked both of those questions. So here's the thing. You always go back to the opening statements of both sides because the opening statements is where they make promises, right? So you look at the opening statement of the defense and they made the promise. I mean, hey, they're not even debating that he hit him, right? They're debating whether or not it was intentional, right? Even when the state was making their opening statement, they talked about the definition of malice and we're going to prove malice. And then he got out of the car and yelled at him and all this other stuff. And then when the defense did their opening statements, they said, well, we have a different side of the story. And then they told their story. And then they said, you didn't think about it that way. And the state didn't tell you that. So at the end of the day, these experts are very, 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 very important for that promise that was made by the defense, right? So I think that it cannot hurt. It's absolutely necessary to have experts to say that because it brings into question, if a jury believes it, obviously, it brings into question the total nature of the incident, because we all know how he died. He died at the hands of the Ford F-250 hitting either him or his car or both, right? So the jury are going to be sitting down wanting to know whether or not it was intentional. So I do think that these experts are important. Do I think he's going to testify? That's a tough one. I always tell my friends, it depends on the vibe you get from your customer when you're in a private conversation with them. I'm talking about the defense attorney and the defendant, right? If you feel that your person, if you ask them the same question 3 times and it gives you 3 different answers, you don't put them on the stand. There's almost very, very few instances where you would want to put your client on the stand. But if you ask him a question 3 times and he answers it 3 times, and then you test your client further and to see if you can invoke emotion, and they don't become emotional. We've seen witnesses that testify in their own trial and emotion matters and they cry, and that's helpful, but everybody emotes differently. For all you know, this defendant, when he emotes and when he cries, it seems fake. There are some people who are genuine. They're at a funeral, they're really sad, but they look like they're not really crying because everybody emotes differently. So you have to get a sense of your customer in a private room to find out whether or not you put them on the stand. However, if this person will hold up on the stand, if I'm his defense attorney, I'm putting him on the stand. I'm hoping that he cries. I'm hoping that he says, you know, I love my wife. Our marriage was falling apart. Our divorce was going to be finalized soon. And he wanted to talk to me. I couldn't say no, but I was not trying to hurt the guy. I've never done anything like this before. And, you know, that would be a very good boon to your defense case because it would allow the jury to see. We know that this jury saw a lot of emotion out of the state. The prosecutor in his opening statement, he was very charming. I think, you know, they say primacy and recency. I think if you end the case with your client on the stand and he's a good witness, I think it will play well for the jury. So that's my thought.